Perfect. Hello, everybody. My name is Danielle Angelari, and I am the Executive Director of NAMI Northern Illinois, which is an affiliate of the National Alliance on Mental Illness. We are here because we are dedicated to improving lives of individuals and families touched by mental illness through support, education, advocacy, and hope. I have very, very few updates for you guys this afternoon. I did just want to start with saying that our next Leading the Conversation webinar will be on veterans' mental health, and we're going to be doing that November 7th at noon with Tavares Moore, who is a licensed clinical social worker. And then I did want to mention that we're gearing up for our annual Gifts of Hope program. For those of you who aren't familiar, we do collect donations, hygiene products, winter wear, really a lot of different things for our community partners and individuals that are in residential care or the hospital living with mental illness through the holidays. So keep an eye out for that stuff. But now to the reason you guys are here today. Everyone has a right to live in housing of their choice, free from discrimination. Our friends and representatives from Prairie State Legal Services will give you an overview of fair housing, including special considerations for people who struggle with mental illness. Nathanial Bovell has been a community resource specialist with Prairie State Legal Services for 3 years. He's responsible for developing partnerships with local agencies and conducting outreach and legal education efforts in the community. He is passionate about helping people empower themselves through access to legal information and resources. Nathanial previously worked with Prairie State for 2 years in the AmeriCorps VISTA program. And we also have Dina Sipiora, who earned a Master of Science in Education from Northern Illinois University in 2019, which laid the foundation for her role in teaching and training fair housing testers about the Fair Housing Act and the testing program. With 2 years of experience as a housing counselor at a local not-for-profit organization, Dina advocated for families experiencing homelessness, providing support to them to find housing and to find secure housing. This experience strengthened her commitment to ensuring access to safe and healthy housing for all individuals. Dina, Nathanial, thank you so much for being here. I'm going to turn it over to you. And just quickly, housekeeping. If you do have questions, you'll notice that the chat might be disabled, but there's a Q&A feature. So as we're going, if you want to put questions in, we will help facilitate those at the end of the presentation. Thank you.
Thank you, Danielle. Good afternoon, everyone. My name is Dina Sipiora. I'm the Fair Housing Project Testing and Outreach Coordinator at Prairie State Legal Services. And Nathaniel.
Hello, I'm Nathanial Bovell. I am the Community Resource Specialist at the Rockford office of Prairie State Legal Services.
And we will begin. So who is Prairie State Legal Services? We are a nonprofit law firm. We provide free civil legal aid, which means no criminal or traffic cases are accepted. Our office is located in the Supply Corps building in downtown Rockford at 303 North Main Street on the 6th floor. And our phone number is 815-965-2902. A short disclaimer, this presentation covers general legal information. We can answer general questions about this topic. We cannot advise you on your specific situation. If you would like legal advice or assistance, please contact Prairie State. Our agenda for today's meeting is to cover the following topics. What is fair housing? The protected classes under the Federal Fair Housing Act and the Illinois Human Rights Act, common fair housing violations. We'll have a short Q&A to figure out if the examples we provide are examples of housing discrimination. We'll talk about reporting housing discrimination. We'll cover some resources, and at the end, we'll answer the questions in the chat. So what is fair housing? Fair housing is the right to choose housing free from discrimination. Housing discrimination is any practice that limits a person's housing choice based on a trait of theirs that is protected by law. Who is responsible for fair housing? Well, landlords, sellers of real estate agents, banks and lending institutions, home insurance providers, public housing authorities, municipalities, agents and employees of the property, even neighbors. So housing providers must not discriminate when selling or renting housing, lending for housing, providing insurance for housing, advertising for housing, deciding about disability accommodations at the property, and interacting with residents. So now we're going to discuss the protected classes. So under the Federal Fair Housing Act, one of the protected classes that are protected against discrimination include race, skin color, religion, sex, nationality, familial status, and disability. The federal law protects against discrimination based on these characteristics. The Illinois Human Rights Act adds additional protections based on age, military status, marital status, protective order, pregnancy, arrest record, sexual orientation, source of income, and immigration status. So first, we're going to discuss source of income. Source of income is the lawful manner by which an individual supports themselves and their dependents. Examples of different types of sources of income include housing choice vouchers, veterans benefits, Social Security income, retirement income, temporary assistance for needy families, also known as TANF, healthcare benefits, Social Security, disability insurance, SSDI, inheritance, child support, and unemployment income. Starting in 2025, reproductive health care decisions will be a protected class. This means that housing providers may not discriminate based on a tenant's reproductive health choices, such as abortion, birth control, fertility or sterilization care, miscarriage management care, assisted reproductive care, prenatal, intranatal, and postnatal care. So common fair housing violations. So the first one we're going to discuss is sexual harassment. There's two classifications. The first is quid pro quo. This is when someone's offered a housing benefit in exchange for a sexual favor. And the second is a hostile environment. This is when a hostile environment is created by any employee, and that includes inappropriate touching, comments, pictures, etc. Next, we're going to discuss steering. So this is when someone is directing a prospective tenant to live in a particular part of the building, complex, or community because of their protected class. So an example would be if someone was looking at a unit and they were told, you might not like this building, but there's another building that you'll feel much more comfortable in based on one of the protected characteristics. If they have children under the age of 18, their race, their military status, those are different examples. Discriminatory policies. So this is where a policy may appear neutral, but has a disparate impact, which means it affects people differently based on their protected class. So an example would be requiring all tenants to pay rent on the first of the month. This could have a disparate impact on different individuals based on whether or not they receive a traditional income. So Social Security payments come in at different times, child support comes in at different times, disability payments. So that would be a policy, rent due on the first, that appears neutral, but again, affects people differently based on their protected status. Retaliation. So it's illegal for a housing provider to retaliate against a tenant for exercising a fair housing right, such as reporting conditions and issues or submitting a fair housing complaint. Other violations can include discriminatory statements, advertising, lying about availability, refusing to rent or sell, different treatment, services, threats, intimidation, coercion. The last two are usually considered retaliation after someone files a fair housing complaint. And the first three, after the discriminatory statements and advertising, lying about availability, and refusing to rent or sell, we have requires testing. We'll discuss that more at the end of the presentation. And now I'll give it to Nathanial.
All right, so next we're going to talk about reasonable accommodations and modifications. So this gets into talking about some of the fair housing protections that exist for people with disabilities. So first we have to define a disability. So a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. So a major life activity would be just any kind of everyday activity that you engage in or a normal bodily function. So that includes things like walking, hearing, seeing, working, or learning. If you have some kind of, again, physical or mental impairment that is, substantially limiting one of those things or something like that, that would be considered a disability under the law. So both reasonable accommodations and reasonable modifications should be allowed under the law to provide people with fair housing. So these are a little different. So a reasonable accommodation is a change in the policy, the normal workings of the place where you're living. So that is a policy change that makes it possible for someone who has a disability to be able to live in and enjoy their housing, in a way that allows them to live in and enjoy the housing despite their disability. And a reasonable modification is similar, where it's also a change to allow someone with a disability to live in and use the facilities. This is actually a change to the facilities themselves. So maybe something like providing a ramp, as you see in this image, to allow a wheelchair user to get into their home, providing something like a floating sink for a wheelchair user, or a walk-in shower or something like that, actually changing the facilities themselves so someone with a disability can use them. So with reasonable modifications in particular, the housing provider does need to allow those kinds of reasonable modifications, but they're generally not financially responsible for actually making those modifications to the housing, unless the exception for that is if it is HUD-assisted housing. In that case, the housing provider might be responsible for making those changes. So there's some criteria to decide if a housing provider is required to allow a reasonable accommodation or a reasonable modification. So the housing provider should allow that reasonable accommodation or modification if they know someone has a disability. So either they have been told that the person has a disability, or the need for an accommodation, or the fact that they have a disability is just clear and obvious. The tenant need a reasonable accommodation or modification to help with the effects of your disability. You request that reasonable accommodation or modification, or the need is just obvious that you would need that. The reasonable accommodation or modification is reasonable, And reasonable means that it's not creating an undue burden on the housing provider or forcing the housing provider to fundamentally alter the nature of their services. And that reasonable accommodation or modification doesn't pose a direct threat to other tenants or property. So it's not threatening the safety of other tenants. It doesn't have a direct threat to the property, to damaging the property. So a housing provider should allow a reasonable accommodation or modification if that accommodation or modification meets all of these criteria. So just to give you some ideas of what a reasonable accommodation for someone struggling with mental illness might look like, some accommodations might include helping someone with completing paperwork if they need some help with that, allowing someone to have a live-in aide to assist them, allowing someone to have an emotional support animal, which is something we're going to discuss more in a little bit, allowing someone more time to clean clutter that was caused by their disability, making exceptions for people who have a criminal history or poor credit, if their criminal history or poor credit are directly related to their disability, or moving the rent due date to when you receive your Social Security disability check to make sure that you do have enough time to pay rent. So these are all different examples of what different accommodations could look like. All right. Now, really quickly, we're going to talk about crime-free and nuisance ordinances. So that's a CFNO for short, crime-free or nuisance ordinance. So crime-free and nuisance ordinances are local laws that penalize tenants or landlords for perceived association with criminal activity. These can cause tenants or potential tenants to be evicted for calling the police, evicted for the criminal activity of a household member or guest, fined for calling the police, or denied housing because of past arrests. Now, one thing with these crime-free and nuisance ordinances is that they can negatively impact people in many protected classes, including people with disabilities. Illinois law does prohibit ordinances that penalize tenants for calling police and other emergency services for domestic or sexual violence and disability-related issues. So that is just something to keep in mind if you are potentially facing eviction or any actions like that because you've been calling for emergency services. That is an example of a situation where you might seek to get some legal help with that situation. That may be a case where you are facing housing discrimination. All right. So next we're going to move on to talking a little bit about service and emotional support animals. This is just an important topic to talk about because oftentimes these aren't taken seriously. These may not be taken seriously by housing providers, but a lot of times these are very important for people with disabilities to be able to live and operate in their day-to-day life. And so it is important just to be aware of this and all the rules about this. So service animals and ESAs are defined a little differently. A service animal is an animal that has been trained to perform tasks for someone with a disability. So it has gotten specific training in order to be able to help someone with a disability. An emotional support animal, or an ESA for short, is an animal that gives therapeutic emotional support to someone with a disability. So they are supporting that person emotionally. They may not have any specific kind of training, but they are supporting that person, helping them operate again in their day-to-day life and social situations, different things like that. So for emotional support animals, unlike with a service animal, an ESA does not have to have any kind of specific training or perform a specific task for a person with disability. An emotional support animal can be any kind of common household pet. If you are requesting to have an exotic animal, an animal that is not usually kept as a household pet, as your emotional support animal, you may need to provide some information or proof about why you need that specific animal. Now, you can request a service animal or an ESA if you have a physical or mental disability. You can request a service animal or ESA even in housing with a no pets policy. That's a really important point to be aware of, that service animals and ESAs do not count as pets. So even if a housing provider doesn't allow pets, that is not a basis for them to reject a request for a service animal or an emotional support animal, because service animals and emotional support animals, again, are not pets. You can request a service animal or emotional support animal in both private and public housing. And you can request a service animal if it performs a specific task for you. And you can request an emotional support animal if it alleviates a symptom of your disability or if it lessens the effect of your disability. So there's no specific limit to how many service animals or emotional support animals you can have. But if you are requesting to have multiple animals, you do need to explain to your housing provider why you need more than one. One possible reason could be that different animals perform different tasks, or different animals alleviate different effects of your disability. So there may be a number of reasons that you need more than one service animal or ESA. You just need to explain that. So when you are making a request for a service animal and emotional support animal, you can request a reasonable accommodation to be able to have that animal either verbally or in writing. There is no required wording or form for such a request. A landlord cannot require you to reveal your diagnosis or reveal your specific disability when you are making this request, but they are allowed to require an explanation of how that disability affects a major life activity and what role the animal will serve. So you might explain, for example, this animal helps me with symptoms of anxiety, helps keep me calm in social situations. That might be an example. All right. When it comes to disability verification, the landlord can verify that you have a disability if it's not obvious that you have a disability. That verification doesn't have to come from a doctor. So, for example, if you get disability benefits, a way you could prove that you can verify with the landlord that you have a disability is providing proof that you receive disability benefits, just as an example. But you can get verification from a licensed healthcare professional. Usually a healthcare professional would verify that for you through a short letter, just explaining why you need the animal. Important just to note that internet verification from an online physician is not enough for this requirement. All right. When it comes to talking about size and breed restrictions, landlords can't deny animals based on size and breed restrictions or stereotypes. So one example of that, we have this picture of a very cute pit bull here on the screen. One stereotype is that pit bulls are violent, they're dangerous. And so maybe a landlord might say, well, we're not going to allow you to have that pit bull as your service animal or ESA because pit bulls are dangerous. That's a stereotype. So that is not a proper basis for the landlord to deny a request, deny a request for a service animal or an ESA. Landlords can only deny reasonable accommodation requests if the individual animal poses a direct threat of harm to other tenants or property. So if that individual animal has a history of maybe destroying property or being aggressive towards people or something like that, that may be a basis for them to deny the accommodation. But again, they cannot deny that accommodation based on size, breed restrictions, or stereotypes. All right. When it comes to pet fees, landlords can't charge pet fees for support animals or emotional support animals. Again, this is because support animals and ESAs are not pets. So it would be discriminatory for a landlord to charge a pet fee for an animal that is not a pet. So the landlord would only be able to charge for damage that is caused by that animal. All right. So we will move on now to talking a little bit about reporting housing discrimination. We've talked a lot about the different forms of housing discrimination that you might face, different ways that might look. And so now we'll talk a little bit about the option that you have to actually report housing discrimination. So you have two main options if you want to report discrimination. The first would be filing a fair housing complaint with HUD or with the Illinois Department of Human Rights. If you want to file a complaint with HUD or IDHR, you do have a 1-year statute of limitations. So the statute of limitations is the time limit for filing. So 1-year statute of limitations would mean that you have 1 year from the incident or incidents of housing discrimination that you want to report. You have 1 year to report that incident. The process is pretty slow. It could be as long as a year or more. So that is something to keep in mind. It's not a quick fix. But one upside is that there is no filing fee to filing a fair housing complaint. The other option that you have is filing a lawsuit with state or federal court. For a lawsuit, you have a 2-year statute of limitations, which means that you have 2 years since the incidents of housing discrimination that you want to report. So you have 2 years after that where you can file a lawsuit in state or federal court. It is a much faster process than filing a fair housing complaint, so that's an upside there. One thing to keep in mind is that there are filing fees for doing this. So yeah, and pros and cons to the different options there. Now, there are several remedies available if you win the case. A remedy is basically a solution, a way that you can get justice if you win the case. So a few examples of remedies include you may get the housing that you were denied, may be able to force the housing provider to make policy changes to make sure that they can't discriminate against you or other people in that way again. You may get monetary damages if you win your case for things like emotional distress, things like the cost of a lost housing opportunity, different things like that. You can get monetary damages for that. Temporary restraining orders, and you can get different penalties against the housing provider that make it very expensive for them to ever discriminate again. So different remedies, different solutions that are available to you if you win your case. All right, so we're going to move over to a little bit of audience participation. So I'm going to show you 3 different scenarios. And since no one can really respond, I guess, in the particular format we're doing this presentation, I'll give the answer after, but we'll look at some different scenarios of housing discrimination. So the first scenario, Jane used to live at a recovery home, and she lists this as her previous place of residence in an apartment application. She is told that she must pay a larger security deposit than other tenants because of her history. So the question is this a case of housing discrimination? This is potentially a case of housing discrimination based on her disability. Because of her disability and the history that she has because of that, she is being treated differently than other people, being required to pay a larger security deposit. So this is a scenario that may be a housing discrimination and would definitely be a situation where she could reach out to Prairie State to request some legal help with that situation. All right, the second scenario, we have this character named John. John has anxiety, and he has an emotional support dog to help him stay calm in stressful situations. He provided his new landlord with a note from his doctor explaining that he will need the animal. The landlord says that Jack will need to pay a pet deposit to have the dog in his apartment. So again, the question is this a case of housing discrimination?
And Nathaniel, people are answering in the chat.
Yeah, I forgot we had the chat, so people can answer in the chat. So I do see some yeses in the chat. So thank you for your participation there. So yes, this is an example of housing discrimination. Again, just like the previous story, John is being treated differently because he has a disability. In particular, as we said before, ESAs, emotional support animals, are not pets, and the landlord is requiring him to pay a pet deposit for an animal who is not a pet. So landlord is not supposed to be doing that. So yes, this is an example of housing discrimination, and John could reach out to Prairie State to request help with that. All right, and we have our final example here, scenario number 3. So we have this character, Sally. Sally has called emergency services 3 times within the past few months. Because of episodes related to her PTSD, she gets a notice stating that she is being evicted for nuisance activity. So what do you guys think? Does this look like an example of housing discrimination? All right, I'm seeing a lot of yeses in the chat. Yes, this does look like an example of housing discrimination. Once again, we see someone who's being treated differently because she has a disability. Specifically, as we talked about before, you have crime-free and nuisance ordinances that we discussed that there can be a disparate impact where someone is being differently or unfairly impacted because of her disability. As we said before, Illinois law makes it illegal for ordinances to affect people with disabilities in this way. So this does appear to be a potential case of housing discrimination, and this is something that Sally could reach out to request help for. All right, well, thank you for your participation in that. And we will move on to tie it up with our conclusion, just to give a summary, because I know that was a lot of information that we covered and that we discussed. But to summarize some of the main points that we went over, you do have the right to choose housing free from discrimination. Both federal and Illinois law protect people from discrimination based on traits that include, but are certainly not limited to, race, sex, disability, and source of income. Housing discrimination, or examples of how housing discrimination could look, include sexual harassment, refusing disability accommodations, and other forms of mistreatment based on these protected classes that are protected by federal and Illinois law. You can seek help if you have been discriminated against for calling emergency services. Housing providers do need to permit service animals and emotional support animals if you take the correct steps. And you can report housing discrimination to HUD, the Illinois Department of Human Rights, or sue a housing provider in court. And those are all options for reporting housing discrimination and potentially getting some remedies and solutions out of that. And I'll pass it on to Dina again to close us out.
Thank you, Nathaniel. So I'm going to discuss the Fair Housing Project at Prairie State Legal Services. Again, I'm the testing and outreach coordinator for the project. So the project investigates and challenges cases of discrimination by housing providers. We use fair housing testing to uncover discrimination or wrongful practices in real estate transactions, and we are 100% funded by the U.S. Department of Housing and Urban Development, HUD. So what is fair housing testing? Well, it's an important tool we use to uncover discriminatory practices in real estate transactions. So back when we were talking about different types of discrimination, including lying about availability or different services or fees, this is where we would use testing. So testing is kind of like being a secret shopper. We train you to pose as a home renter or buyer to gather information, and then you report back on your experience. We work with the attorneys here to kind of evaluate those experiences and move forward with different actions if we think there's discrimination occurring. We use the test reports as evidence to support if we believe that someone is experiencing discrimination. Testers earn cash stipends and learn new skills that look great on a resume. If anybody's interested in applying to be a fair housing tester, you can request an application at this email address, fairhousing@pslegal.org. We have different resources that provide information about fair housing. First of all, you can look at our website, pslegal.org. /fair housing. This is resources on fair housing, fair lending, and sexual harassment in housing. Illinois Legal Aid Online provides articles, court forms, and help in finding legal aid. And finally, we can move to our questions. So, and if you have any questions that you want to put in the chat as well. So we have a question, Nathaniel. Do we offer immediate assistance to advocate sooner than 1 year? In filing a complaint is what I'm assuming, Dorothy?
Yeah, I think that's what that means, like with filing a fair housing complaint.
Okay.
Oh, yeah, Dorothy
Yes,
explained in
thank
the
you,
chat.
Dorothy. Yeah. So if there's an issue with a housing provider, to resolve a matter sooner. Yes, you can reach out to Prairie State Legal Services or contact the Fair Housing Project and we can get involved. Yes. And then will we explain a temporary restraining order?
Yeah, so this may be, is this in reference, Dina, to, I know we spoke about fair housing, we spoke about uh, one of the potential ways that a fair housing discrimination could look is sexual harassment. Is that what this is in reference to? Talking about, helping people with getting protections against someone who has harassed them in housing, or someone who's been threatened by a housing provider.
I think it's like a temporary restraining order. She said it was part of what you presented, Nathaniel, but I believe it's like
Okay.
like an order of protection.
Mm-hmm.
So to explain a temporary restraining order, we are not attorneys. So I am not kind of comfortable explaining that. Nathaniel, do you have more that you want to add? Because under the Fair Housing Act, you are provided protection if you are a victim of domestic violence. So if you have an order of protection or a restraining order, you would be considered protected. But explaining, again, I'm not an attorney. I can pass that question along to an attorney, Dorothy, and they can get back to you if that would be okay.
Mm-hmm.
And then do we offer assistance with writing a request for reasonable accommodations with housing providers? I think if you communicate to your housing provider that you're requesting a reasonable accommodation or modification and they decline it, then you can reach out to Prairie State. Correct, Nathaniel? But it first begins
Yeah.
between the tenant and the property owner or manager.
Yeah. I'm not sure for certain, um, but I do believe, certainly if someone has um, uh, had their request denied, that becomes a fair housing issue if the housing provider was supposed to be providing that service or providing that accommodation. In the initial request, I would certainly say people are welcome. I think our attorneys help with a lot of things in terms of drafting letters and ghostwriting things. So if someone is seeking help with something like that, I believe it would be appropriate for someone to reach out and request help with that.
Thank you for your questions, Dorothy. I'm going to try to go back to the slide with, but I don't think I can actually,
Oh yeah, which slide?
with the fair housing projects at email address. Thank you, Nathaniel.
Oh, this one. Okay.
Yes, so there is the fairhousing@pslegal.org email address. If you have any questions or concerns or are interested in applying to be a tester, we do offer paid training, and then you complete a practice test, and then you are ready to go on testing for rental. We also offer training on lending testing and insurance testing. So if anybody's interested, please send me an email and I can send you the application. Oh, great, Dorothy. Thank you. Please send me an email. And thank you, Danielle.
Thank you both so much for all the information. If there's anything you would like to send that you want me to send to the participants today, I'd be happy to do that. If you want to share your slides, like as a PDF, I could share as well. And also just your contact information again, just in case anyone has questions as they leave today. Awesome.
Yes,
Thank you
absolutely.
both so much.
Yes, thank you, Danielle.
We look forward to seeing you again.
Yeah, thank you all so much for your time.
Thank you, everyone.
Have a good day.